Hello everyone. My topic for the presentation is Gram Panchayat of village Jamalpur versus Malvinder Singh and others, which was decided on 9th July 1985 by the Honorable Supreme Court of India. Citation of this judgment is 1985 All India Report 1394. Author of this judgment was the then Chief Justice of India Y.V. Chandrachud, and bench consists of five judges, which were Honorable Justice Y.V. Chandrachud, Honorable Justice Syed Murzat Fazal Ali, Honorable Justice V.D. Tazal Pushkar, Honorable Justice O. Chinnappa Reddy, and finally Honorable Justice A. Vardarajan. Petitioner of this case was Jamalpur Gram Panchayat, and the respondent of this case was Malvinder Singh and others. So, coming to the facts of the cases, I'll give the brief facts of the cases. The case was related to uh, the time of the partition. During the partition, what was happened that the migrants Hindu who were being prosecuted in Pakistan after the partition were coming to India, and it was the responsibility of central government and state government to give them living measures like land and to incorporate them. In the same way, many Muslims left India after the partition and they went to Pakistan. So their land were emptied. This case basically revolves around the Punjab and Haryana and their partition, and in this way it talks about the land which were owned by the peasants in Punjab and Haryana. So what happened is the Punjab government has made an act which was related to the evacuees property. So evacuees properties are basically when the major amount of people left their lands and went to different countries. The property which was left by them is known as evacuees property, and these evacuees property must be used by the people who are coming to India after the persecution from the different parts. So in this way, Punjab government has passed an act which was known as East Punjab Evacuees Administration of Property Act 14 of 1947. Section 4 of that act says that all interest in the property, whether movable or immovable of the evacuees, vested in the custodian appointed by the state government. This act of the state legislatures was repealed and replaced by the act passed by the parliament, that was Administration of Evacuees Property Act 1950. So what happens was the Punjab government has passed a certain act, and that was also for the same purpose, but the power of the custodian was of state government. Later on, central government has passed the act on the same subject matter because this uh, entry number 41 entry number 41 was under the concurrent list, so both the state government and central government can make the law on that. After they have made the law on entry number 18, which was also related to the agrarian reform related to the land, both the entry number 41 and entry number 18 has more or less same kind of property regarding the enlistment. So they have also made a law in that. Then what happens is uh, the Punjab government also enacted one law which was related to the same conflict so that the Punjab village can use the common land for that purpose. So section 3 of the Punjab Village Common Land Regulation Act was enacted in 1953. So there was three acts. The conflict basically was who will be the custodian of the property. And then there is one more concept which is known as Shamlat De land, which were in easier term can be known as common lands for the villagers. An issue was that if the evacuees property act of the central government will be implemented, then evacuees will get those lands. The people who are coming from the from the Pakistan Punjab side, they will get the land. Those Hindus will get the land, and the people who are already living here and using that land as a common property or common land will not be able to use that land for that self. So that was the whole conflict. Issues which came before the High Court earlier were since both the government, central government, state government, has made a question related to the same entry. So, what will prevail? And the question was also that is there a repugnancy between the central law and state law? High Court has applied the doctrine of repugnancy, which has been provided under Article 24 of our Indian Constitution, which says that if there is an inconsistency between the law made by parliament and law made by the legislature of the state, the law of the central or parliament will prevail. It has few exceptions, like if the law is under the consideration of the president, and if president later on give consent to the state legislature's law, then that state legislature law will be prevailing. Then one more issues which was prevailing was that the law which was given for the consideration of Punjab was not the whole act. It was only Article 31A, 31A, and related to the and other provisions related to the property. Since it was a specific provision which were given for the consideration, whether this doctrine will be applicable fully. Then there is a concept of cooperative federalism also. Like since both the government intention or objective was to help the people who are coming from Pakistan after facing the partition. So there should be a cooperative federalism and it should be a harmonious construction also. So what High Court held that there's definitely a conflict between the laws that are Section 8, Subsection 2 of the Administration of Evacuees Property Act of 1950, which was enacted by the central government or parliament, and Section 3 of the Punjab Village Common Lands Regulation Act 1953, which was enacted by the state legislature. So in this, government was also of the view there should be a custodian appointment for the allotment of the proper land of the common grounds. Later on, what happened is High Court also decides that although following the doctrine of repugnancy, we can say that central governments evacuates land, that act which is known as Administration of Evacuees Property Act 1950 should prevail. But after seeing the nature of this property, in this judgment very beautifully they have explained with respect to the Abadi Day, that is the same land which I have already talked about, which is used for common purpose. The setting of body of agriculture artisan, such as the village carpenter, the village blacksmith, the village tanner, ferry, wheelwright, barber, washerman, etc., is a part of rural planning and can be comprehended in a scheme of agrarian reform. It is a tried saying that India lives in village and a scheme to make village self-sufficient and cannot but be regarded as a part of the larger reform, which consolidation of holding, fixing of ceilings on land, distribution of surplus lands, and utilizing the larger reforms and utilization of vacant and waste lands contemplate. The four acts, namely the Consolidation Act, the Village Panchayat Act, the Common Land Regulation Act, and the Security of Tenure Acts, are a part of general scheme of reforms, and any modification of the rights such as present had the protection of Article 31A. And they have also quoted the agrarian reform, the marketing. So basically, High Court also held that although the repugnancy exists and central law should prevail, by following the custom of the land, and there's a very famous common digest regarding the land laws of Punjab. In that also, the primacy was given to the Shamlat Day lands, which were used by common people of the villages and the nearby people. So, if that land will be allotted to the evacuees, and if that land will be allotted to the people who are coming from the Pakistan side of Punjab, then the rights of these people will be infringed. Moreover, if we go by the legal aspects, then also the property will be then also the property, according to the doctrine of repugnancy, since the central government has not made the law regarding the common regulation of the land, and moreover the property and the act which has been given to the main proprietary, and since if you go by article 254 clause 2, then also the consideration which were given to the president, which was not a full, it was only to the specific part of the legislation or specific part of the act, that is section yes, this act, sorry, section 3 of the Punjab Village Common Land Regulation Act 1953. Therefore, the law and the doctrine of the repugnancy will not be applicable fully. So, basically, High Court finally held that the agrarian reform, which has been brought under Section 3 of the Punjab Village Common Land Regulation Act 1953, will be given due consideration, and the repugnancy which is existing in this case is only of academic nature, not of the persistent nature. Therefore, the law which was brought by the Punjab government later on, that is Punjab Village Common Land Regulation Act 1953, will prevail. Then it was challenged before the Supreme Court, and Supreme Court also of the same view, and which was also beautifully explained by O. Chinnappa Reddy, that the due primacy should be given to the common lands and the by the specific common digest which is applicable in the Punjab land laws. So therefore, this should be given primacy, and the repugnancy is only of academic nature, and therefore it should not be bothered with. And later on, the Y.V. Chandrachud has also explained that in important case law, that is Kanjit Singh versus State of Punjab, the very question whether a law provided for the taking away of Shamlit Day land from the proprietors and given over to the Punjab village panchayat for allotment to non-proprietors was a law related to the agrarian reform, and whether such a law was protected by Article 31A. It is worthwhile to recall what Constitutional Bench has said. They have explained the amplitude of rural development and agrarian reform in the following words. The High Court was also right in its view that the proposed change in the Shalmat Day and Abadi Day were included in the general scheme of the planning of rural areas and the productive utilization of the vacant and wasteland. The scheme of rural development today envisages not only the equitable distribution of land so that there is no undue imbalance in the society. So basically, in this case, what was given the primacy was the customary law related to Shamilat Day and Abadi Day over the power of making law under Article 254, although it was not applied fully because the Article 254 2, the requirement of the sending of that law to the president, or sorry, the act to the ordinance to the president, or the act to the president, was for the full act, but the consideration was asked only for the specific provision. Therefore, Article 254 was not fully applied, and moreover, the agrarian reform was also necessary. Therefore, this act was held constitutional of the Punjab government, and therefore they have also, it is also the part of the cooperative federalism between the central and state government over the agrarian reform, over the agriculture, and as to the laws related to the evacuees property. Thank you.